Jack Smith is begging Judge Cannon to reverse herself. He did not like the fact that she said, you and I in America can see more of the record in the Florida classified docs prosecution case. Doesn't want us to be able to see any of that stuff because Jack says there is some problems, maybe witness security problems, or there's other things that might wreck America. You know how this is. National security secrets, classified documents, all that stuff. And so he submitted this. It's a motion for reconsideration. And this comes on the back of Cannon ordering that this stuff would start to be opened up. Said, okay, Trump, submit your proposals to us and we'll consider opening it. And then I'll let you know. So Jack just submitted this one. Please reconsider, Cannon, please, because we're all going to die if you don't. Here is what it looks like. This comes from Jack Smith, the so-called special counsel, not even lawfully appointed. He's whining again. Back over to Judge Cannon, Southern District of Florida, West Palm Beach. It's a 22-pager. We'll hit the highlights. United States of America versus Trump and the co-defendants. Tells us, this is Jack Smith speaking. Your Honor, in two recent orders, the court, you, Cannon, you have denied the government's request to seal or to redact certain material. And that was provided to Trump and the defendants in their discovery pursuant to the protective order. And then attached either to the defendant's motion to compel or the government's responses here too. And that discovery material, says Jack, if it's publicly docketed in an unredacted form as you ordered, Judge, it would disclose the identities of numerous potential witnesses along with the substance of the statements they made to the FBI. It's like, perfect. That's what we want to see. Thanks, Jack. It would also expose the substance of their statements or the grand jury, exposing them to significant and immediate risks of threat and intimidation and harassment, as has already happened to witnesses and to law enforcement agents and to judicial officers and to DOJ employees whose identities have already been disclosed in cases in which Trump is involved. All right, singling out Trump. All right, Jack. And now he's going to go after Judge Cannon, right? He's basically saying you screwed this up, so you need to reverse yourself. Now, this is not something that attorneys do, lightly. Like, it's very difficult to get a judge to reverse themselves on anything, as you know. But here, asking a judge who just wrote out a whole opinion in writing, like Judge Cannon's just going to go, oh yeah, you're right. I didn't think that through. I guess I'll change it. Thanks, Jack. And send it back in. No. So this, now we start asking ourselves, okay, what's the following step? Is he appealing this? Or is he going to appeal this? Because if he appeals it, then we have questions about whether the underlying case is stayed or Trump says it's stayed or, whatever. And maybe that delays the case and the potential for a trial on this if you believe the trial on this could go before the election anyways. But the point is, what is next? Okay, reconsideration. If she obviously comes back and says, no, I just wrote this like yesterday, what does he do next? So now he's going to go after Cannon. He says, okay, to reach this conclusion, Judge Cannon reasoned first that because Trump chose to attach those discovery materials to court filings, that the government bore the burden to say that these needed to be sealed. But the court then found that Jack Smith, remember Jack Smith and his justifications, Trump said, can I unseal? Jack said, no. And he explained, no, because he said, well, generic things like witness safety. Okay, what are you talking about? Like, can you give us some specifics on this? Cannon said, I don't want your broad generalizations. Give me some details. Grand jury secrecy or the integrity of the trial, right? Like this garbage crap they say, to save democracy, to protect the judicial process, to sanctify the integrity of the justice system. What are you talking about? Can you give us some specifics here? And don't tell me that you're just getting some complaints or some bad tweets on X or something. Relax. This is Trump. This is a national case. This is a national election that you chose to file this right in the middle of everything, right? You waited multiple years to bring these claims, and now here we are. So now everything is just about witness safety. Justify it, right? Now he says that the court says that Jack Smith failed to satisfy their heavy burden because it was so generic and bland. Like, okay, give us something. Now, Jack says this conclusion was wrong in two respects, Judge Cannon. This is why you're wrong, and this is why you should reverse yourself. Says first, here it comes. The 11th Circuit, your bosses, has held that the compelling interest standard applied by the court does not apply to documents filed in connection with motions to compel discovery. So you applied the wrong standard and you might get reversed on this. The government has readily satisfied that standard here. Okay, you held us to a higher standard, but we've already met our standard that we think is more appropriate. Now, because you, Judge Cannon, you applied the wrong legal standard, which as explained below, the government did not discuss in its prior filing, they say reconsideration is warranted to correct your clear error, right? And there's another appellate standard. Clear error there, you're reversed. Now, second, in addition addition to ensuring that the correct legal standard is applied, reconsideration here is warranted. You better seal these documents, elsewise it's going to cause manifest injustice. So reverse yourself to prevent that. Now, this order, it requires the public identification of more than 24 people who participated in the investigation. And recall that part of Trump's efforts in this case were to properly define the scope of the prosecution's team. Jack Smith says it's just me and like my bros, like they're sleeping on my bunk bed over here, and we go to Subway sandwiches to get footlongs. But that's it. Like, you know, a couple FBI agents, couple prosecutors, that's it. No one else was involved. Trump says, yeah, right. What are all these emails then with NARA, the Secret Service, the January 6th Select Committee? Looks like the CIA was involved. Looks like the DOD was involved. Every stinking agency in the government was involved. And so that is part of the prosecution team. And we'd like to know more about that. So we're having a conversation about the hula hoop, right? What's inside, what's outside. And they say, right, Trump says, look, there's 24 people here. So we want to know information about them. So if it's part of the discovery, we got to identify them. That's how it goes. Now, Jack says, that's a lot of people. You know, we don't want all these people being exposed. So some, they say, may never testify at trial and therefore would otherwise be able to retain their anonymity and their privacy unless Judge Cannon, you out them, right? So they may not even show up to trial. Maybe they're not even going to be called. Now, others are expected to provide important trial testimony. And if they're going to come in, like, in other words, if you know who these people are, that's the big question. Who are these people? 24 people? Why would they get all sorts of threats? Who are they? Will likely be subject to threats, to intimidation, and to harassment if their identities are revealed. Oh, who could they be? I wonder. No wonder he's so freaked out. Now, a likelihood that is concrete and palpable in this case, as the record reveals, and as other judges have recognized. Now, he didn't give us a lot of this specificity in the prior filings, and Judge Cannon called that out, said, I don't want to hear about your witness, concerns. Like, relax. Give me some more details. At least now we know it's 24 people. That's the problem, is he doesn't want to reveal to us, Trump's people know what a lot of this is, or they know where the gaps are, so they can see, all right, it's like a puzzle, and it's going to be the Eiffel Tower, and you're missing some pieces of it, but you go, that's definitely the Eiffel Tower. You're like, the puzzle's not done, but that's the Eiffel Tower. I know what I'm looking at right here. And so I just got to go find those pieces. And that's what they're doing. So the First Amendment does not require the disclosure of these witnesses' identities. And particularly, whereas here, their identities have no bearing on the resolution of the motion to compel. And this is Trump's motion, the motion to compel, which was, again, to define the size of the prosecution team, to get NARA, Secret Service, and all of the other entities. It's not relevant here. Their identities, they have no bearing. We don't need to hear about that on the motion to compel, which is talking about the agencies. And so protect those people. Now, the government, therefore, respectfully requests that you, Judge Cannon, reverse yourself and reconsider its orders. Can you imagine telling a judge to go reverse yourself? Unbelievable. Its recent orders and to permit the sealing or the redaction of exhibits that identify any prospective government witnesses. They may constitute Jenks Act material, which are like their notes, memos, reports, or contain certain sensitive information described below, saying the government further requests that the court stay the orders that direct the parties to file the new submissions before February 9th. That's today, pending the resolution of this motion to reconsider. Now, the government has communicated with the defense counsel, which you're supposed to do before you file this type of stuff, and they oppose, obviously. Here is what Trump's defense said when they were reached out to by the prosecutors. They say, Judge Cannon, while you're considering this, they say, Trump defendants, they object to Jack Smith's efforts to reconsider. After full briefing, whether there is a valid basis under the law to seal the motion to compel briefing. Trump reserves the right to respond to any new authority cited by their office within a reasonable period of time, and we do not oppose an extension of time to submit proposed unredacted submissions to permit the court to consider the expected motion for reconsideration. So Trump says, we're objecting, we're kind of anchoring it in there. We're not foregoing any further objections. We're just letting you know, you gotta, kind of investigate it and we'll let you know. But we do not agree with you reversing yourself, Judge. So here's some more background from Jack Smith. They say, okay, on June 16, 2023, the government came in, they sought a protective order. They want to govern the handling of unclassified discovery in this case. There was a protective order entered and it governs. Now, the materials also include information pertaining to ongoing investigations, right? These are from the court filings. It said that defense shall not disclose the materials, right? So the protective order says you got to do these things. Now, from that time until now, they say, Judge Cannon, so you gave a protective order, and until now, no witness names have been mentioned on the public docket. And the court has actually admonished people, says anonymize your references to witnesses. But then on January 16th, so they're saying, look, we had a standard here, Judge. Like, we were already going through this and there were no witness names that were being unredacted that everybody could read and see. We'd know who they are. And suddenly now, Trump on January 16th, all this time has gone by and we thought this is how we do business. But then they filed their motion to compel. And in the latter motion, they made no attempt to show why an exception to this presumptive confidentiality of the protective order was warranted, like why they should be allowed to not, follow those rules. Now, 2 days later, consistent with the protective order, so they're saying, Judge, we're just following your original ruling. The government responded to the motion and opposed it, said this is going to, reveal a bunch of stuff. They said, Judge, it's going to identify government witnesses. It's going to identify their memos, their notes, and it's going to contain certain discrete sensitive information. And so on February 2nd, the government filed a motion in connection with this as well. But then the court came out and granted Trump's motion, says, okay, you can, pursue this. And the court granted their request for unsealing as to the names of potential government witnesses and their statements. And Jack's like, what? Based on its conclusion that the government, Cannon said this, and we read this earlier this week, said, Jack, you didn't carry your, quote, heavy burden. You didn't show us that there is a compelling government interest that is met here. And so she issued a ruling saying, yeah, you can start to unseal this, file some more stuff, and we'll talk about the redactions. And Cannon's ruling was based on the premise that Jack didn't articulate an actual compelling government interest. He just said, witness safety, integrity of our investigation, all that stuff that we just read. And it's not enough. So they say, all right, Judge Cannon, here's the deal. This is the law that says you basically got to reconsider yourself. Says here are the bases for it, right? But here's the concept. Reconsideration is an extraordinary remedy that should be employed sparingly, right? It is not used hardly at all. You can file it, judges, deny it, and they'll probably remember you. What'd you ask me for that, right? I'm not an idiot. I know what I wrote down the first time. So they say there are 3 grounds that justify it, and they're going to make the argument that that is met. Now they then tell us about public access to discovery material. Okay, what is our right as America that has an interest in this prosecution, against the leading candidate for president, which I'm sure after Joe Biden's most recent press conference, that margin's going to increase. But they say, look, both First Amendment and the common law, they grant the press and the public a qualified right of access to criminal trial proceedings and to judicial records. But that is not absolute. The right to access discovery materials is not a part of the First Amendment, is what they say. The First Amendment right of access is only when the tests of experience and logic have been met. So they're going to say when you get it, right? In other words, your First Amendment right of access is limited by discovery rules, right? In other words, you don't get everything that the government has in their file. You're not the criminal defendant, and there are some protections and limitations under the First Amendment, saying so long as a court has found good cause to issue the protective order, the constitutional right of access is satisfied, right? So a court has found you don't get access to that, that's enough. And Judge, you found that. So the common law right of access is also inapplicable. So don't come through this back door and say you can get access through common law, right? Your protective order supersedes that. In some, they say, the discovery materials, including materials attached to the discovery motion, do not fall within the scope of the First Amendment. And so the press can't get it, Trump can't get it, America people don't get it. It does not fall within the scope of the First Amendment. And so, the ultra-transparent prosecutors here are silencing that under the First. They say it doesn't apply. So they say, Judge, reconsideration right now, reversing yourself, is warranted. You got to correct your clear error. As explained below, you, Judge Cannon, you put the wrong legal standard in. And what you've done is you're going to expose witnesses and others to intolerable and needless risks. Now, before addressing those issues, we're going to address the procedural objections. Now, although the government is cognizant of the fact that motions for reconsideration should not be used to present new evidence or argument, reconsideration is appropriate here for the following reasons. They say, Trump, they were not legally entitled to a list of the government's witnesses. And remember also, what's interesting about this is we don't really know what they're talking about, right? It's all under seal, it's all redacted, it's all classified, ex parte hearings, and you can't see anything. Drive me nuts! But we do know that Trump's team went through a bunch of other avenues, public records requests, Freedom of Information Act requests to go obtain these materials. And so they know, I think even more than the government is letting on. They know about this stuff. And they're saying, we got this from this other avenue. So we're just attaching that, right? I think we don't know the sources of the information per se, directly, the chain of connection where it came from. But what I'm expecting, sort of filling in the gaps, is that they got something from FOIA that they're attaching. They're saying this is not from Jack. And then they're saying that's going to expose stuff that we've already got. Now, they're not legally entitled to a list of witnesses. The rules say the purpose is to protect the government files of the Jenks Act from unwarranted disclosure. But the government has still produced those materials and more far in advance of trial in minimally redacted form, but only because the materials were subject to a protective order that allows them to prepare for trial while avoiding unwarranted disclosure. Like we gave them some things with their promise that they wouldn't disclose it. The order says that. That is precisely why no discovery was provided until we gave the order. And while the order permits them to seek approval rule, the procedures presupposes that the burden is on the defendants to justify their basis. So we're talking about burden shifting. Who has the burden on either side? Does Trump have the burden to show why it should be made public? Does he have the affirmative showing? He's got to make his case and overcome the burden? Or does Jack Smith? The presumption is that it's not public and Trump has to overcome that. Or does Trump have the burden that it is public and Jack Smith has to overcome that? So to justify the basis for publicly disclosing this. Now, a contrary rule, they say, would turn the principles of discovery on their head. Here, Trump may not evade the protective order by just filing stuff as an attachment and then claiming that their unilateral decision converts those discovery materials into judicial records. That's what it is. So Trump, they don't like the information that he's attaching. He probably got it from a FOIA. They're attaching it. They're like, that's us. Okay, that's what we were going to give you, but you got it from somewhere else and we don't want that on the record. And Trump's people are saying, no, it's not discovery. It's not discovery. We got it from FOIA. You didn't give us that. So that's why we attached it. We just slapped it onto the back of the document. It's not subject to the protective order. So the government relied on the full protections of the court and the protective order and did not understand that it would be required to provide specific additional evidence to support line-by-line redactions of materials that had been found under good cause to seal. So in light of this context, even if the court finds that our prior filings did not adequately address that, you should exercise your discretion now, Judge Cannon, and consider the arguments below, adhere to this for continued sealing, saying the witnesses should not be placed at risk, if you know who these people are, simply because the government is relying on its good faith understanding of the protective order. Now, they give us a lot of kind of analysis on the good cause standard. Trump made the unsealing requests. Now, the government objected to those. Why? They said there were some problems. It reveals the identity of witnesses. It reveals the personal information of the witnesses. It is our internal notes. And so in doing so, there remain concerns. We have to protect our witnesses from harassment and intimidation. We have to avoid infecting the testimony of other witnesses. So if one witness hears another witness, that other witness may adopt their statements. We have to avoid impacting the jury pool. And we need to protect personal privacy and the disclosure of uncharged conduct of more people. Kind of an ongoing investigation exception. We might charge them. Now, those legitimate concerns greatly outweigh the public disclosure of that information. The risks are far from speculative also, Judge Cannon. As early as August 2022, Judge Reinhardt, who was the judge who issued the warrant, the search warrant in Mar-a-Lago, he noted back in August, he said, there's a dangerous atmosphere for witnesses in this case. He maintained under the seal the bulk of the Mar-a-Lago search warrant affidavit. He said that FBI agents who were involved in the investigation were threatened and harassed. I'm sure they were. But while they're the FBI, maybe they should go investigate them and arrest them and charge them with crimes like is within their power. Don't you just love that? Judges complaining about FBI agents being threatened and harassed. Oh my gosh. They're the FBI. They can go make an arrest. Given the public notoriety and the controversy of this search, he said it's likely that even witnesses who are not even named would lead them to being harassed and intimidated. Okay, so even witnesses who don't have their names in there, well, they might be threatened by those MAGA people. So a magistrate Judge Reinhardt himself has been subject to numerous direct threats. Every one of those is illegal, all right? And they'll investigate them and arrest those people. So, they're victims and victims and victims. Therefore, the public doesn't get access to the materials. Now, there is a clear and demonstrable pattern in which numerous people had their lives turned upside down, Judge Cannon, after being publicly identified. The presiding district judge in the election case received a racist death threat. Oh, no. And the special counsel and his staff have been subject to threats and harassment. Again, all illegal, and I don't condone any of it. It's wrong, and nobody should make threats or harass people or make racist death threats. That is a wrong, bad thing to do. And it's already illegal. So you can just go and arrest those people, right? And the law already says that. You don't need an additional remedy. The law provides a remedy. Go charge them with the crime. That's what the law's there for. You don't get to then use that as justification to then, not allow America to see one of the most important trials of all time in the middle of an election season when you chose to bring the case against the leading political opponent of your party currently today. You get to say there's bad things happening because you brought the case. So you get to cause the prosecution and then say that your prosecution created a response that justifies the silencing of the prosecution. Very convenient. The chambers of the justice presiding over the civil fraud case. Oh yeah, this is Areola Angeron, okay, and his GF, his Greenfield. They have been inundated with hundreds of harassing and threatening phone calls, I'm sure. And potential witnesses against him, the Areola, are routinely subject to the sorts of threats. So they just parlay it off one another. It's like a snowball effect. So that judge engages in egregious conduct, okay? He is, co-judging with his clerk the trial. When the attorneys call him out on it, they get gagged. Even the lawyers get gagged. And he moves the cameras so you can't see what's happening there under the desk. I don't know what's happening. But He moved the cameras. Why? And then they say that guy, right, is now facing threats. Okay. So, and potential witnesses against him are routinely subject to threats. So therefore, you, America, don't get to see what Jack Smith is doing because they're scared. Now, the court's conclusion that the government's witness safety concerns are too speculative or generalized is also misplaced. A court's duty is to prevent harms to witnesses. And in this case, common sense and common human experience, which prosecutors don't have either of. I don't know, where are they referencing this? Did this come from their life? It sure didn't. Common sense? No. Common human experience? No. Okay, good. They're quoting it from another case. That's good. Yeah, it doesn't come from themselves. It comes from this case. Apparently this case is United States versus Nixon. Oh, good. So Supreme Court said it, not prosecutors. So in this case, common sense and common human experience, quote, teach that hostile messages regarding evidentiary cooperation that are publicly relayed to high-profile witnesses have a high significance, a likelihood of deterring, chilling, or altering the involvement of other witnesses. So if we know who these people are, one of them might crack and then they all might crack. The government has not invoked concerns about witness safety or trial integrity in a boilerplate or speculative fashion, other than referencing areola. Witnesses, agents, they have been harassed, they have been intimidated, and the further outing of additional witnesses will also pose the risk of turning these witnesses' lives upside down, because the Trumpers. Now, those significant interests in maintaining confidentiality also greatly outweigh the disclosure to the public. It does. Now, as noted, because those materials were attached to a discovery motion, no public right of access attached. And moreover, Trump and the defendants have not articulated any basis for why they need to publicly disclose witness names or statements. And those details have little relevance to the resolution of the motion to compel, as discussed below. Well, we have a right of access. We have a presumption of access, first of all, and witness names and statements are going to tell us a lot about the case and the legitimacy of the case. The government's legitimate interest in confidentiality outweigh the interest in disclosure. This is your DOJ saying you don't have a right to know what their case is. Now, a recent decision in the middle of an election, right, against an electoral candidate, a recent decision in another district illustrates this point. But they say, Judge Cannon, you better fix this. This is the, we're going to appeal your butt threat. Reconsideration is warranted to prevent manifest injustice. If you don't reverse yourself, there is going to be so much injustice, it's going to make your head spin. Reconsideration is also warranted because it would be a manifest injustice if we know the identities and the witness statements in this case. There is a well-documented patterns where Trump cases result in threats, harassment, and intimidation. And we've seen already similar harms impacted a witness in this case. Oh no. As detailed, they're in a sealed ex parte Exhibit A. So we don't get to read that either. I'm sure it's a very racist statement. Why are you such a racist? You know, whatever. And they are likely to befall many more if the court reveals their identities. The court should not ignore this reality. People are going to face harm, and Trump hasn't justified why this should be exposed. So the government's redaction requests were narrow. They were well justified. Of the 70 exhibits that they attached in their motion, we sought relief for only 28. And for only 17 of those did we propose any redactions beyond personal identifying information. We don't need to know their social security numbers, you know, or their addresses, but names, sure. Yeah, for 6, the government requested sealing in full. So 17 partial redactions, 6 full seals. And in connection with the government's opposition, the government sought sealing in full of 3 exhibits and other limited redactions. So here is where we get into some interesting things. We can see if we can glean anything about what's inside these exhibits and these materials. Here are the exhibits they say that should be sealed in full. Do not want us to see what's inside of these at all. Government exhibits A, C, D, and Exhibit 2. Those are FBI 302 reports of interviews with potential government witnesses. They include career civil servants and former close advisors to defendant Trump. Oh, yeah, that's why we want to see it. Now, the government's inclusion of and reference to these exhibits was necessary only to correct the false narrative that Trump included in their motion to compel, but it did not present a factual dispute that you need to consider. So it's like they're irrelevant, right? That's what we want to know. Who are these close advisors to Trump? Are they, you know, friendlies or not? Are they actual close advisors, or are they, you know, the other close advisors that Trump had a lot of? On the other hand, revelation of these witness identities or the substance of their interviews with the FBI FBI, it dangerously risks exposing them to the same type of harassment that Areola got. Indeed, the witness whose statement appears in Exhibit D, he declined to have his interview recorded, citing the associated risks to him in, quote, Trump world of doing so. Who is that? Who is that person? It's a close advisor to Trump who's like, the Trumpers are going to kill me if they hear what I'm telling you right now. Don't record this. I'll tell you what happened, but don't record it, okay? If this ever goes public, I'm a dead man. Who is it? Exhibit D also contains the witness's opinions about other potential witnesses and information about the case and other witnesses have revealed, but that are not public, as well as information about uncharged, potentially obstructive conduct by a defendant and speculation about witness tampering by an uncharged individual. Lot of juicy meatballs in there. Exhibit 51 is another FBI 302, an interview that is Jenks material for a potential government witness. So again, Jenks materials are like, think of like police reports, officers' notes, memoranda, supplemental things that they may use. It is cited for two propositions that find support elsewhere in information that the government is not seeking to redact. So we've got citations for one, agents from various offices, and also FBI coordination with the Secret Service. Again, the Secret Service. Both are already available, and so there's no reason to publish any of this material. It's not relevant. And Trump, again, is trying to say that the Secret Service are part of the actual prosecutorial team. They're inside the hula hoop, not out. Exhibit 59 is the DOE, the Department of Energy memo that was discussed at some length in their motion. Remember, they found that Trump still had a security clearance. They're like, oops, you do still have one. And then they like revoke that. So Trump brought that up. The only redactions that the government seeks in this exhibit to redact are the names of the author and the recipient of the memo. The individuals' names are irrelevant to the court's association. We got the memo, we got the author and the memo. You don't need to know who wrote it. Another one is FBI 302. This is an interview of a potential government witness who worked for the White House Communications Agency. Who is this? The witness provided extensive non-public details regarding enabling the sitting president to have secure communications and to review classified docs. Trump cites the exhibit in support of their generalized discovery request for evidence related to secure facilities at Trump's residences, but none of this sensitive information is necessary to resolve this dispute, so keep his name under seal. Now, some of these I think are important and some of these are not important, right? They're establishing a standard here. They're saying, well, here's like Exhibit 61, like truthfully, maybe they don't care if it's sealed or not, but they're really, really interested in Exhibit 59 or Exhibit 51. Probably more likely that. Exhibit 51, right? But they cover the other ones in there. Okay. Like we'll fight over Exhibit 61, but if we got to let that one go, we'll let it go. Exhibit 67 and 68. These are transcripts of interviews of potential government witnesses that collectively reveal the details of their interactions and their relationships with certain defendants. And so that's Trump or Walt or Carlos. Another big one. Like they're probably going to fight on that one. To describe the process of finding attorneys, both of whom were identified and they are potential government witnesses. Trump cites this for the proposition that the government questioned a witness about Stanley Woodward's representation, but this doesn't advance any of their claims. Exhibit 69 is a 4-page excerpt of a transcript from a grand jury testimony of a witness before the grand jury. The excerpt also relates to the search warrant that was executed at Mar-a-Lago and also includes non-public details about the layout of the private residence, like the location of Trump's son's bedroom, which they probably raided after Melania's underwear. The defendants cite the exhibit to support their request for discovery, and they say Trump doesn't need it. So here are some things that should be redacted. Okay, so I think these were what, sealed? Backing up? Yeah, sealed in full, right? Don't see anything about any of that. Then there are redactions. So 1, 3, 4 through 7, 10 through 11, and 18, those either consist of or contain NARA emails, which many speculate was the entire location where this all started. The redactions that are sought are witness names. Don't want those names. Witness statements. They say that's Jenks Act. Also contains information about the uncharged conduct, including about a person unconnected to this case who hasn't been charged. Why not? The defense have publicly alleged with no basis that NARA was part of a government-wide scheme targeting Trump. I think there's plenty of basis. We read their entire motion. But there is no reason to publish the names and unnecessarily intimidate numerous NARA officials who have only done their jobs. Wrong. This goes to their credibility, to their bias. We want to know who these people are. What's their background? Who appointed them? Who are they donating to? What types of political rallies are they attending? Who are they taking pictures with and posting it on their Instagrams? That's what we want to know. That's part of, I think the public needs to know in order to verify whether this is legitimate or not. 25, and they want it redacted. 25 is a list of discovery requests from the defendants that are letters from the government in response. Now, the redactions are also detailed in the appendix. These materials are relevant. That they're relevant does not make them appropriate to unseal, so we can't even read their letters. So Trump sends a letter. Hey, I want want all this material. I want this and this and this and this and this. They say, no, I'll give you this, but none of that. Trump wants to make that unsealed. So we can't even read the government's response. Are you nuts? They say it's not appropriate to unseal. None of the names of the 4 potential witnesses mentioned in Exhibit 25, or the 3 mentioned in Exhibit 27, which are their letters back, or the 9 mentioned in Exhibit 29, which is another letter back, is even remotely germane to resolving any of their requests, and so there's no justification for putting them at risk either. 33 is an internal FBI email that details a witness interview and provides the names of other potential witnesses. The government wants to redact their names and their emails. The defendants cite to another exhibit that has nothing to do with their names, and the government has not sought to redact the portion of the exhibit that they really want, so there's no basis for their names. We unredacted the things they want, so we can leave their names redacted. Also, the exhibit contains Janks Act material. Also, there's a special agent that knows about sensitive information about classified documents, and so we don't want that disclosed. They also say that 52 is going to show that the Secret Service coordinated with the FBI. And again, the government has not requested redaction for the stuff that demonstrates that, but they want to show that the FBI and the Secret Service were great partners, but there's no basis in law for that, and so we don't want to reveal any of the names. We have Exhibit 70, last one, that is an FBI internal email chain that includes statements from multiple government witnesses about other details that relate to the search of Mar-a-Lago, and a list of names of the FBI personnel who were present for it, all the names. The government seeks to redact the list of names and specific statements made by the witnesses about non-public details of the search. That is a good one. What did they say? Defendants cite Exhibit 70 with a self-contained list of every FBI agent who was present there, a search that Trump has called a raid by the Gestapo, which is absolutely true, to establish unremarkable positions that they were communicating throughout their search as they were going through their sock drawers and underwear drawers, and that 2 DOJ attorneys were present, saying the court should not tolerate this barely veiled attempt to slide into the public record by first and last name the participation of over 20 FBI personnel in the search. They don't want us to know who did it so that they can hide in the dark of night and not be responsible for their actions. Oh, no, I didn't do any of this. What are you talking about? The government asked the court to reconsider its orders and reverse yourself, Chutkin. Otherwise, we're probably going to appeal this. Signed by the typical Jay Bratt down in Florida, and sent that one in to Judge Cannon, and Judge Cannon seemingly entertaining it, saying, okay, Trump, why don't you respond, and then I'll make my decision on how this should all unfold. And we'll be here to continue to cover it, my friends. We've got a lot of Trump litigation ahead. Things are just starting to heat up. And so thank you for subscribing and liking this video wherever it is you're watching this. And I really appreciate you bringing a friend or family over to come and join us as we go live. We've got a lot of great cases to cover here, a lot of fun conversations to have. We've got some other great stuff in the links in the description wherever you're watching this. Watch Your Lodge. We've got some great events in February coming up. So go sign up for free over there, watchyourlodge.com. And then come on back here. We've got a Trump reply to read through when it drops. We'll be here to do it. We hope you join us as we do. We'll see you back here on the next one.